Good afternoon and welcome back. The next panel this afternoon will discuss the function of defence, the role the Association of Defence Counsel has played, and the future of defence organisations at international criminal courts. The ADC was created in September 2002 and officially recognised as the only association of defence counsel at the ICTY. Compulsory membership was incorporated into the Rules of Procedure and Evidence, requiring all active defence counsel to be members of the association. Although the ADC was established originally to fill the gap and give defence at the ICTY some body by which to be represented, it effectively became the de facto defence office. This was a compromise between full recognition and no recognition at all. Since its inauguration, there have been over 350 members coming from over 25 different countries. During the 3 years I spent as head of office with the ADC, it was clear that the association had become an essential player for communication and cooperation between defence counsels and other organs of the tribunal. The association has acted as a collective voice for all defence counsel and continues to support all members to ensure that the rights of the accused and the defence are protected. I would quite happily speak more about the ADC, but I'm going to leave that to the panellists. I would now like to introduce our distinguished panellists. First, we have Judge Bocconi Justice Moloto. He has been a judge at the ICTY since 2005, sitting on various trials. Prior to joining the ICTY, he was a judge at the Transvaal Provincial Division of the High Court of South Africa, focusing on constitutional matters and reviews of proceedings in the lower courts. He has also served as a judge at the Land Claims Court of South Africa, hearing disputes arising from South Africa's Land Reform Initiative. Judge Moloto acted as Executive Director and is a former trustee of the Black Lawyers Association Legal Education Centre. He is currently sitting on the ongoing trial of Ratko Mladic and is also a judge assigned to the Mechanism for International Criminal Tribunals. Next on the panel is Mr. Eugene O'Sullivan. He was one of the longest-serving defence counsels at the ICTY, first assigned to represent Janil Delilich in 1996. Since then, he has been assigned as defence counsel in a number of cases before the tribunal. Eugene has been a long-standing member of the ADC Rules Committee, representing the views of defence counsel in relation to amendments to the Rules of Procedure and Evidence. He is currently representing Salim Jamil Ayash at the Special Tribunal for Lebanon. Our final panellist is Mr. Stefan Bogon. He is a military academy graduate, former officer, and military legal advisor. He has worked in the Office of the Prosecutor and subsequently the Chef de Cabinet in the Office of the President. Since January 2002, he has acted as defence counsel, representing a number of persons, and is currently assigned to represent Drago Nikolic and Mitja Stanisic. Stefan has served 2 terms as President of the ADC and 1 term as Vice President. He is currently a member of the Disciplinary and Rules Committee for the Association. Stefan was also recently appointed as the amicus curiae investigator at the Special Tribunal for Lebanon to investigate allegations of contempt. I'd now like to give the floor to Judge Moloto.
Good afternoon to everybody. I hope we didn't eat too much during lunchtime. But if we did and we want to fall off to sleep, please, by all means do so, because I'm not going to be telling you anything you do not already know. When Mr. Novak asked me if I could speak at this conference, he said to me, the topic I should speak about is the function of the defense in international justice. And I agreed. How presumptuous of me to come and talk to defense counsel about their function when I've never been one in international justice. Very, very presumptuous, I must say. But be that as it may, I'm going to tell you my little thoughts, and you are welcome to add to them or subtract from them as you please. In my view, the function of the defense counsel in international justice is no different from the function of the defense counsel in a domestic jurisdiction. In fact, I would dare say that the functions that are crafted into the framework of the defense counsel in the international justice system were taken from the domestic jurisdiction. So what I say about the function of the defense counsel in the international justice would be equally appropriate for defense counsel in the domestic jurisdiction. The main important function that a defense counsel must think of at all times is the very obvious one: defend your client. And defend your client to the best of your ability. And refuse to be browbeaten by anybody in the exercise of that duty to your client. Whether that person is from the prosecution, whether that person is a judge, or whether that person is any other counsel. Your job is to defend your client. And if at the end of the trial, whatever the outcome, you can say, I couldn't do any better, then you are entitled to peaceful sleep. That's the most important function. Now, subsidiary to this function, there are a whole number of rights and obligations that attach to the accused. And it is your function as defense counsel to make sure that those rights and duties are observed where they have to be observed, and the obligations are performed where they have to be performed. I just want to mention a few of the rights and obligations that pertain. It's not an exhaustive list, but it's a few of those that I regard as very important. The first one is, and I'm dealing with the rights first, there is a presumption of innocence in favor of the accused. And this presumption needs to be guarded very jealously by counsel who defends the accused. You must make sure that nothing gets into the evidence that comes as a conclusion that the accused is guilty before judgment is given. What comes in is an allegation. It's subject to testing through cross-examination. It's subject to verification in the light of the entirety of the evidence to see whether it is the kind of allegation that can stand firmly against the accused, and make sure that that never happens, that an allegation comes as fact. Facts are facts, allegations are allegations, and a clear distinction must be made between the two. The next important point, and there's been a discussion about this a few moments before lunch, is the right of the accused to be tried in presential. He's got to be in court. It is his right. If he doesn't attend court because he chooses not to, it is his right to waive that right. Now, I understand that there are certain jurisdictions where accused are tried in absentia. I'm not going to talk about that. I'm talking about the international justice system as is practiced by what I would regard as the majority of institutions in the world. It is the right of the accused to be present in court and to be able to hear the accusations against him so as to be able to give appropriate instructions to his counsel on how he understands the evidence and how counsel can, having heard that understanding, put it before the court. The the accused has the right to confront his accusers. And this is the one major function that is being performed by defense counsel on behalf of the accused when he, as counsel, confronts those who are accused, the accused, those who come and testify for the prosecution against the accused, and even those who come and testify in favor of the defense. It is for defense counsel to make sure that he confronts those witnesses who testify against his client by way of cross-examination, and must ensure that he covers the entirety of his theory of the case. Now, let me be understood on this point. Certain people think that cross-examination means you just go to ask questions. You don't just ask questions, you ask relevant questions, pertinent questions to the point at issue. And some questions, although they might be relevant to the case, they may not necessarily be relevant to your theory of the case. And you need to concentrate on those points that have to do with your theory of the case so that you stay within the theory of your case from beginning to end. I know, and I've seen in many trials, that cross-examination seems just to go anywhere and anyhow without any purpose. This, to my mind, is unfortunate because it suggests that counsel doesn't know what his theory of the case is. And if you do not know your theory of the case, if you do not know what your defense is, you cannot organize a meaningful cross-examination. You're going to be asking questions to fill up time, and time is money. The fourth right that the accused has is the right to a fair and expeditious trial. And what do we mean by a fair trial? A fair trial, as again was being mentioned this morning, is ensured by having a public trial. And yes, I will concede upright that the protective measures that are being given to some witnesses have to some extent a negative effect on the fairness of the trial of the accused. But again, that's a balancing of rights and of the rights of the accused with the interests of the witnesses and the victims. But to the extent that the trial is predominantly public, to that extent is the accused assured of a reasonably fair trial, because as the trial is going on, so are the proceedings being judged in the eyes of the community out there. And without that judging by the eyes of the community, the balance goes, the trial is not fair. Now, we all know of the saying that justice must not only be done, it must be seen to be done. And who must see it to be done? Not the judge, but the community out there, society out there. We owe it to society. We're prosecuting this accused in the name of society. And society, as the institution that mandated us to do this job, is interested to see that trial is fair. What do we mean by expeditiousness? Expeditiousness, again, is explained by another phrase that has yours truly's name in it. Justice delayed is justice denied. So it is important, to the extent possible, to make sure that the trial comes to a conclusion as quickly as possible, taking into account all other problems that have to go with trials, which may cause a delay. The delay must be a reasonable delay, must not be unreasonable. Reasonable in the sense that the reason for the delay is justifiable, and the length of the delay is also not excessive. The accused has the right not to incriminate himself. That is why the accused may or may not testify in his own cause, according to what he chooses to do, or according to what his counsel advises him to do. Again, it is a strategic decision, this one. It's usually taken by a counsel. Let me take a step back. It's not taken by the counsel. It's taken by the accused, preferably on the advice of counsel. If counsel knows, or at least if I were counsel in a case, and I said to my client, it's dangerous for you to take the stand, and he insisted on taking the stand, I would make him understand that he does so at his own risk. And I'd take no responsibility for that, because he's come to me as the technician. The technician to help him with his problem. If he could prosecute his own case, he could do it on his own. You don't go to a motor car repair shop to repair your car and then tell the mechanic how to do it. You hand the car over, and the mechanic decides to do what he does, and he builds it. That's it. So should it be with defense counsel. If my client is not going to take my considered opinion, my considered advice, he's on his own. The accused has the right to lead evidence in rebuttal of the accusations against him. And again here, with the help of counsel, you've got to choose your witnesses strategically according to the theory of your case. You don't have to call anybody who's enthusiastic about testifying in favor of the accused, irrespective of whether what he's coming to say is or is not relevant to your theory of the case. And I keep coming back to this point of the theory of your case because certain evidence on the face of it appears relevant to the case, but it may not necessarily be relevant to your defense, and it is therefore not necessary, in my view, to lead evidence which is just relevant to the case, even though it is not relevant to your defense. So, you are going to be working with the accused to select those witnesses that you think support your theory of the case, and you, as counsel, as knowing what kind of information you want from them, are the one who must decide what questions to ask those people and what evidence you want them to put before the court. And of course, here comes a very important part in the game, control of your witnesses. It is counsel's responsibility not to put a wide question to a witness and expect him to rattle away for 10 minutes far beyond the question that was asked. You've got to get just that information that you asked for. And when you've got that, the witness must stop and you can ask the next question. One of the means of control is to ask very simple, one-fact questions. Where do you live? What's your name? What's your father's name? Where were you on such and such a day at such and such a time? You get almost monosyllabic answers, but very clearly focused to the question, and do not allow the witness to rattle away and maybe say things you might regret at the end of the day. So that function by defense counsel is a very important one, particularly when leading your own witness, over whom you are supposed to have absolute control. But it's equally important even when you are cross-examining. The practice at the International Criminal Tribunal for the former Yugoslavia, and I dare say also at the ICTY, has inherently in the system some kind of infringement of the next right I'm going to talk to you, of the defense. And that is the right to have sufficient time to prepare one's defense. Now, this, unfortunately, is a systemic problem which the two tribunals can do nothing about. And it is systemic simply because they are temporary institutions that must come to an end, and therefore there is pressure to come to an end. And when counsel says, I need 2 weeks to prepare for this, or I need 6 months to prepare for that, or I need 3 years to prepare for that, it becomes important for the bench to balance that request with the need to complete the cases and bring the institution to a close, which is not that very important in a particular case if fair trial rights must be respected. However, that right also has an opposing right within the rights of the accused. We just mentioned the right to have an expeditious trial. So, long delays, again, which are not justified, infringe the right to expeditiousness, even though they may still be at the request of the accused. So, there comes a need to balance those two and give the defense counsel sufficient time to prepare, but not just time because that's what the time he asked. Got to look at the task at hand in comparison with the time that is reasonably required to achieve the task. The last right I want to talk about, and it's not the last of the rights of the accused, is the right to have counsel of his choice, if he's paying out of his pocket. Now, this may or may not be a problem again in international justice, particularly at the tribunal. I'll keep referring to the ICTY because that's the one I know best. Because there are certain regulations, and there are regulations even domestically about this point. I might want counsel to defend me who comes from Timbuktu and is not a member of the ADC. And depending on how much time is required for that man to get himself on the list, and when my case is due to start, I may or may not be allowed to get counsel of my choice. It becomes important for those administering the system to take that into account, that if that is the client's choice, then counsel must be given an opportunity to come on the list of ADC members to be able to defend his client, provided he qualifies. And of course, if he doesn't qualify to become a member of the ADC or qualify to appear before the tribunal, that's just unfortunate. The accused must try next door. So far, so good about the rights. But side by side with these rights are the accused's obligations. And again, I'm going to mention very few of them, not as many as the rights that I've mentioned. There is the obligation to treat the evidence fairly. I've observed counsel on many occasions paraphrasing what has been said by a witness. And in so doing, putting a twist to what the witness has said, resulting in embellishment of the evidence. You know, a simple example that comes to mind would be an answer by a witness saying, well, I think it did happen. And then counsel says, oh yeah, you just told us it happened. Now, you are obviously embellishing that witness's evidence of useless. He doesn't know. The correct answer is he really doesn't know. What he's telling you is not fact. What he's telling you is what he thinks. And because he just says, I think, it happened, you then want to draw the conclusion. And you squeeze it in by your next question that it actually did happen. Now, it becomes important for your colleague on the opposite side to be alive to that kind of embellishment and make sure that when that happens, he can jump up. It is also the job of the bench to make sure that you don't embellish. But primarily, it is our opposite numbers' responsibility, because in typical ICTY situations, which is it 70%, 80%, 90% common law, the judge is but a referee. He doesn't descend into the arena, as we say in the common law systems. So, whereas he's there to ensure that the game is played according to the rules, it is also your colleague on the opposite side to bring that balance and make sure that we don't embellish the evidence. It's not only evidence that must be treated fairly, it's to treat witnesses fairly, particularly witnesses from the opposite side. That's the second obligation. It doesn't matter how uncomfortable the questions you put to the witness may be. They must be put in a fair and respectable and respectful manner. Don't harass the witness on the opposite side. Don't trick the witness on the opposite side. Make sure, if you have to quote what the witness said, you quote exactly what he said. And that's why there is a practice in the tribunal that insists on counsel going back to the transcript. Thank God we have that thing called ECOD to say, if you are going to put the answer of the witness back to him, read what was said. Don't paraphrase. And because that's an example of an unfair treatment of the witness. And it is actually tricking the witness.
Sorry.
Am I late? I'm sorry. Be that as it, okay, if that is the case, I just wanted to say that, finally, that you have the duty to act honestly and honorably towards the court. You know what that means. We've been talking about ethics this morning. Finally, here is the most important function of the defense counsel from the point of view of the community out there that mandated us to prosecute these cases. That function is your contribution towards the development of the law. The tendency to see defense counsel as stepchildren of the system should be driven out of our minds, and we must accept that their submissions, their arguments go a long way to contributing towards the jurisprudence and the development of the law. Thank you so much. I'm sorry.
Excellencies, dear colleagues, ladies and gentlemen, I wish to thank the organizers of this conference for inviting me to come here today to speak to you. And I think all of the defense counsel here fully understand and respect your robust independence, Judge Moloto, for daring to go over time with Judge Bonamy sitting in the front row. I won't dare do that. In the context of this legacy conference, I thought I would speak about the role of the ADC in two ways. I hope to remind those of us who have been on this journey here for the last almost 20 years of some of the accomplishments, some of the things we've done, some of the inroads we've made into ensuring that the defense counsel do their work well, and also by giving an account of that. Those of you who are perhaps new or newer to this field can see that what the mantle is passed to you, the work is not done. And as you become defense counsel or prosecutors or other players in these international courts, hopefully you'll keep in mind and learn from what we've been through. I think everyone knows that the Defense Council or the ADC has never been, or was not, and has never been an organ of the ICTY. I also think it's fair to say that at the ICTY at the beginning, the defense was an afterthought. Very little planning seemed to go into how to deal with the defense, how we would function within this tribunal. And that, coupled with the perception of, they're defending the bad guys, they may be undermining the mission of this tribunal by trying to get the criminals off, becomes a part of an institutional perception of the defense. And that's something the ADC helped correct to a certain extent, and I will try to develop those points right now. As Dominic Kennedy mentioned, the ADC was created and formalized in 2002. And at that point, if we were not an organ of the court, we certainly became a pillar. We had our membership was a requirement to practicing. We had a code of conduct. And I'm proud to say, I think, that as defense counsel, we had to abide by a code of conduct, contrary to prosecutors and judiciary who, when they act inappropriately, don't necessarily and do not face the same sort of review and disciplinary actions that a defense counsel can face. Also bear in mind that in 2002 we had almost 8 years of proceedings before the court. So with the creation of ADC, we had a unified voice that could meet with and discuss with other organs, the permanent organs of the ICTY, and in particular the registry. And I think it's worth noting that there was lots of tireless time and commitment by many of our colleagues who sat on the executives, who sat on the different committees, whose work, by and large, is taken for granted, as we all know. When things go well, no one says anything. When there are problems, people tend to complain. So I wish to acknowledge all our past presidents, all our past members of all our different committees and executives for their dedication, their commitment, and all the long hours that they put in. Since 2002, you've seen growth in the composition of our organization. Considerable time has been spent trying to secure proper funding and composition for our defense teams. That's an example of the thanklessness when it works well and the criticisms when it perhaps doesn't work as well. There's been recognition of the ADC as an institution outside the court, outside the tribunal, despite the fact some emails are not answered at certain times. Our membership has grown and we've trained people. We've had since probably early 2003, 4, 5, numerous trainings where we come together and share experiences among ourselves and with future younger people. I think a sign of maturity of our organization was the fact we had a discipline committee which would self-regulate our conduct. We made amicus submissions before the ICTY. Again, a sign of maturity on our part. For better or for worse, we were a part of the evolution or devolution, however you want to see it, of the rules of the ICTY because of our membership in the Rules Committee. And indeed, I think it's worth noting that defense presence at the Rules Committee predates the ADC. It was the late Judge Richard May who insisted on defense being present at the Rules Committee prior to the ADC, and he also insisted that OLAD or the registry support our presence by ensuring that we could travel to The Hague to attend. And now, our most recent committee is the Ad Hoc Post-Tribunal Matters Committee, and I think it is fitting that at this point, this may be one of the last conferences we have when there's a full functioning ICTY and a full membership as we have today. And can I ask everyone also to acknowledge, in particular, all the different heads of office we've had over the years who worked, I would say, more tirelessly than the past presidents. And I think all the past presidents who are here today with us will acknowledge that it's the head of office who made sure that the ADC was a vibrant, functioning organization. Let me end with two personal accounts of the importance of the ADC. The ADC is, among other things, an important repository of information for those of us who practice here. It created a sense of collegiality. It provided assistance to us all. And the anecdote I'd like to tell, Stéphane may remember this, it was a pre-ADC period, a pre-internet days. And remember, there was no website. We had a great difficulty obtaining interlocutory decisions, pleadings, everything that was filed in a case other than your own. Everything was distributed to you as counsel by fax. And it was John Ackerman, His Honor Judge Morrison, then known as Howard, and I came up with the idea that we would request from the tribunal registry a copy of each interlocutory order, decision, all jurisprudence, all the things we take for granted now by pushing a button. We would scan those documents and distribute them by email. And Stéphane, who was the chef de cabinet of the president in those days, organized a meeting with the three of us, the president and the registry. We explained our position, our request. It was agreed, and as soon as the meeting ended, we were told by the registry, you're not getting any of these documents. You can't have them. It was a completely deflating moment. We weren't going to reconvene the meeting with the president. They weren't going to do it. It became the impetus for pushing for the creation of an organization like this. Now, I don't think that's just a quaint historical anecdote. It is, I agree. But it also shows that from time to time there will be new challenges, new points that must be fought for, and this is a never-ending story. When there's new situations, new technologies, new circumstances, we must always be vigilant and be pushing in the direction to improve our ability to do our work. The last point is recruitment. And the intern program, I think, is a huge success that has been led through the ADC. And that would include legal interns, investigators, and legal assistants. We now have a full-fledged community of people who came here 6, 7, 8 years ago when the internship program started, who are now junior lawyers. And I'm sure this room is full of people who have just arrived recently as well in The Hague and are keen to learn more about the practice of international criminal law. It's hard to believe that there are now several generations, 10 years of people who have studied undergraduate programs of law where your coursework includes international criminal law, graduate programs in international criminal law. Your work is invaluable. All counsel who have had the opportunity to work with any of you are grateful, and we pass the torch to you, and I think it's your responsibility to continue doing the work. I can see Judge Boyman looking at me, squinting at me. It must be time to stop. One other major accomplishment of the ADC, and one that's repeated again tonight at 8 o'clock at the Hudson, I believe, is the best Christmas party the ICTY throws. Thank you.
I was wondering if I should do like Judge Meron and take the little bench. I won't do it. It's a close call. Lord Bonamy, Excellencies, Honorable Judges, Mr. President of the ADC, Novak Lukic, Mr. Mr. Moderator, dear colleagues, ladies and gentlemen, where to from now? Where do we go? You've heard about the ADC-ICTY, but the fact of the matter is, and I hate to be the bearer of bad news, but the ADC-ICTY is about to disappear. Why is this so? Well, it's a very simple equation. Less trials, less counsel and trials, less members, less dues, no head of office, no association. So, what's our problem? Problem is, and this we have been experiencing since the beginning of the ADC-ICTY, either you are a counsel in trial and you have no time to get involved, or you are a counsel back home and you're not interested. So, what do we do? Well, the question is there a need for a defense organization? You'll see from the title of my presentation, of course there is a need. And let's look first at the purpose of a defense organization. If you are from the judiciary, or if you are from the registry or from the UN, you see it from one point of view. You see it at the point of view of protecting the integrity of international criminal law proceedings. You see it as protecting the legal profession and protecting the public and, of course, the clients or the accused, making sure that they get good representation. If you are the counsel, however, if you are the practitioner, well, you want the protection of defense counsel in what they do on a daily basis. Next slide, please. Let's take a look at the both kinds of representation as to what a defense organization can and cannot do. Let's take a look at the, first of all, the protection of the defense counsel. The first thing a defense counsel, first thing a practitioner wants, he wants to be able to do his job. He needs the resources to do his job, and he needs the time to do his job. If he's not given the time or the resources, he's not able to do his job. Nonetheless, I know from seeing my colleagues for the past 10 years or so, no matter how much resources we get, no matter how much time we get, we always continue fighting to the end. But that's what one of the protections that we are looking for. Of course, we want good working conditions. And of course, defense counsel also want some kind of legal representation. What do I mean by legal representation? Well, we all know right now, I think in this room, that there's something very special happened a few days ago at the ICC, where you have 4 members of the same defense team are being charged with contempt. They were arrested in 3 different countries, and now they are facing proceedings. Not for me to speak on their behalf. That's not the point. The point is, it's a major issue of having 4 members of a same defense team facing such proceedings, and there must be an organization somehow who will at least look and ensure that they will be treated with due process. That, of course, is having a seat at the table. We never had a seat at the table. When I was president of the ADC, a couple of times we were invited at the plenary session and we could speak to the judges. It's a practice that had since disappeared, or at least that is very limited, and that is, in my view, plainly wrong. The judiciary must hear from the bar, from the defense bar. Now, looking at the other perspective, diplomatic representation. Of course, here when I talk of diplomatic representation, I have mostly the ICC in mind. An Assembly of State Parties just finished a few days ago, I think yesterday as a matter of fact. Where is the input of the defense into this big conference where you see hundreds of people, diplomats and the like, coming together to discuss the future of the ICC, and the defense point of view is, if not ignored, treated very, very remotely. We, of course, in terms of discipline, my colleague Eugene mentioned that. This is a sign of maturity, where you can discipline your own, and I think that is very important, to have an organization that will be able to discipline its own. To have quality control, yes, there has to be some an entry price. There has to be minimum requirements before you can practice before the courts. Now, strangely enough, the defense have those minimum requirements, which we don't see on the prosecution side, but that's a different issue altogether. Training. We need an organization that will see to the training of defense counsel. We don't want defense counsel to be left on their own to do the training. There has to be some organization that will look at and organize such training and see that defense counsel get the proper training. And again, a seat at the table, which simply means that, of course, we want to get involved into the creation of the rules. This is one of the success of the ADC-ICTY, where for the past, for some years now, we have had some input, at least, in the rulemaking process. Let's take a quick look at a few existing models, now that the ADC-ICTY is on its last about to go. Advantages and disadvantages of some. Of course, it's limited time, so I'm not going to say too much about each. But let's look first at the what happened at the ICTR. At the ICTR, membership was voluntary. The association was not recognized, and the association had no power whatsoever inside the tribunal. Is it because of the choices this association made? I'm not going to comment on this. But however, it is for sure that the defense function was completely fell under the umbrella of the registrar, therefore removing the independence of defense counsel, and it was a very difficult relationship before that tribunal. What about ICTY and the MICT? Well, here we have the ADC model. It's a compulsory membership into an association that is recognized. We feel that this is a very good model, and it has proved to be very successful. However, it also has its deficiencies, whereas the defense function still falls under the umbrella of the registrar. And when you fall under the umbrella of the registrar, you are but one of his concerns, and you are not what we should be, a pillar in the judicial process. The next one, of course, is the ICC, where a new model. You have an office called OPCD, who is there to assist defense counsel or to represent defense counsel. Then you have another office called Counsel Support Section. Two different sections that don't speak to one another. In terms of the work that can be provided by the OPCD, this is something that is puzzling. At least it's something that we need to learn to work with. I've always believed that any work done inside for a client I represent had to be done inside my team, and I will not let anyone outside of the team get involved into my case. But maybe that's something that can be developed. As for the management of resources, there has to be some input for all the people who are qualified and admitted on what we call the list of counsel. There are more than 400 members on that list. 400 defense counsel having more than 10 years experience, senior counsel, want to work at the ICC. Yet, other than for a yearly reunion, or what they call the defense counsel seminar, which must cost an arm and a leg, and I'm not going to say it's a waste of money because it's always good to meet, but whether it's money well invested is a different matter. So we need some kind of an organization to represent the counsel before the counsel support section. And of course, again, the defense falls under the registrar. Now we get to the Special Tribunal for Lebanon, probably the best model so far, because simply the defense is an organ of the tribunal. So if you talk about a seat at the table, well, the chief of the defense office meets with the president, the prosecutor, and the registrar in what they call senior management board. So it is a model that works. It is probably the best model we have so far. But for some people who are working at the STL and the defense, there are also some deficiencies that you probably would entertain. So it's not a perfect model, but it is probably the best one we have so far. A quick idea, a quick look at, when we look at these organizations, is there's a dilemma that always happens. And that dilemma Maybe I should have the slide later, the next slide. Yes. One of the dilemmas, the slides are upside down, that we have is some defense counsel prefer to work alone and entirely alone. And they say, I will fight with the tribunal and I will get the resources because I know how to put a memo together and I know how to do my timesheets and I'll get more resources than buddies sitting beside me in the courtroom. Other people take the view that no, for institutional matters, we need the representation of an organization. This is the view that I share, but it is difficult to get organized. If you go back to the previous slide, this is what we're looking for in terms of an organization protecting the defense, both the function of the defense and the practitioners themselves. Independence is number one. We need to be able to do our work without any pressure and without any fear of any pressure from the outside. The ability to represent, being able to do our job. The working conditions must be minimal, at least to be able to play in the same field as the prosecution. Legal representation in case of problems. Diplomatic representation, I mentioned that already. Discipline, quality control, make sure that we have good defense counsel, at least qualified defense counsel, and of course, training and influence in the decision-making process or the rule-making process. So, another question that comes after this is that from the ICC model, we know that there are two types of counsels. There are the defense counsel and there are counsel or victims' legal representatives. I'm going to say very little on that, other than, and I know some people will disagree, but I think that the work performed by counsels, I have some of my colleagues who do both defense and victims' legal representation. That's not the issue. But when you do one or the other, the priorities and the work done is very different. I think that if we are going to have an association that represents both types of counsel, it should be divided in order to ensure that there are no conflicts between the aims of each. A proposed model that we have, that exists today, is the International Criminal Bar. It was created in Montreal in 2002. It was a wonderful concept, and there were many members. However, for a number of reasons, the influence of the International Criminal Bar has been greatly reduced over the recent years. Various reasons explain what happened to the International Criminal Bar. One is that it focused only on the ICC and not on other tribunals such as the ICTY. There were too many bars involved and not enough practitioners. And of course, it was the association was not meant to represent the practitioners. I have a vision. I was going to say, I have a dream. No. A vision simply of an organization. I think it is possible to have one type of organization that could do everything. And I have even an org chart. As a former military, I can't do a presentation without putting, of course, an organizational chart. The org chart, or the ORBAT, for those who are... So, yes, an international criminal bar that would take care of both functions, and that would, of course, represent both the victims' legal representatives and the defense counsel, each having a separate representation in between the two, where training is there, amicus curiae is there, external affairs and fundraising, and publications, communications committee. And then, of course, taking care of all aspects of being a counsel, whether it's for the victims or the defense. This morning, Mr. Lukic said that it was a pity that we sent a bunch of letters. I was on the fundraising committee for this conference. It was a total failure, other than for one wonderful organization. And I take this opportunity to say thank you again to the Erasmus program. This was wonderful of them to believe in the defense because nobody else did. I think we should actually, just for this, because they are the only ones who did it. Everybody else said no. We need some kind of representation for external affairs and fundraising. I'll stop here. My time is up. Thank you very much.
I'd now like to open the floor for any questions that anybody might have. Keita, do you want to come over to the microphones?
Good afternoon, and thank you for this invitation. My name is Xavier Jean Keita. I'm the principal counsel of the defense, the OPCD that you were quoting, Stéphane. Just to correct something, because I was assisting 2 days ago Emeki Lolo, who is presumed innocent, and who is the Bemba principal counsel. And just to correct that, there were 2 members of the Bemba team, the principal counsel and the case manager. The others were external of the defense team. This is the first correction. The other thing I wanted to precise, my feeling as a defense counsel is that I was shocked, of course, because some counsel were arrested with a kind of violence, if I may say, and I just imagine that a bazooka was used to kill a fly. The thing is, and I raised my concern 2 days ago, that first of all, I wonder what was really the timing to do that at this moment, just before finishing the case. Secondly, what about the consequences? Because yesterday there were in the main case, status conference, and OTP was saying that the 2 counsel remaining in the team may face a conflict of interest to continue the case. And my third concern was 2 days ago, what about the role of OTP being at the initiative, at the origin of this special investigation, even if it's allowed by ICC text? I think that in certain circumstances, because of fair trial, OTP, who is the party, don't have to be involved at all, but it's an external body. This is my concern. Of course, if they are guilty, and nobody can support that. If they are not guilty at all, it will be difficult when you have been in prison to kill completely your name. So I appreciated your concern about OPCD and your vision. You are very optimistic. And I think that it's a moment to help ICC because we have a new register, and he's about to restructure the registry, including perhaps my office and the victim office. So we will need your legacy and your experience to move forward. Thank you.
Any other questions?
Thank you. My name is Chris Ingalls. I'm currently with OSC in Bosnia, formerly working for the Office of the Criminal Defense in the Court of BIH. I just wanted to add a bit to what you were saying, Stéphane, and more generally the role and the legacy of the ADC and its members. And that is in Bosnia, where we have now the Criminal Defense Office that is modeled on Sierra Leone and looks very much like what we see in Cambodia, and has also contributed to this development of what we need and want to see in a defense office. The difference being there that it's now a domestic institution that takes serious the role of defense and provides training and advice to defense lawyers. So it's taken what are some of the best practices from these organizations that you mentioned and applied them domestically, and is now integrated and fully run by the Bosnian government. And to the legacy of individuals who are members of the ADC, it's quite a big honor and pleasure to say that out of the 4 of you up there, 2 of you were actually instrumental in providing that training, Judge Malato and Eugene. And in addition to that, several other colleagues here, members of the ADC, have been incredibly helpful in coming to Bosnia to strengthen the capacity of defense, taking the knowledge that they gained here in the tribunal and as members of the ADC, and transferring that knowledge to defense lawyers representing alleged war criminals in Bosnia and Herzegovina. So I think that as there's definitely one aspect of the ADC which has provided a model and a forum to be expanded on the international spectrum, also the ADC and its members have done quite a lot and contributed significantly to what we now see as a role for defense and a defense office within domestic institutions. So, and I want to say thank you to all of you here who have contributed to that. Thank you.
Are there any more questions?
I have a question for Stefan. Stefan, thank you very much for a wonderful presentation. And I saw you have the bigger picture in terms of the future, which you presented there by way of an organogram. My question is a very narrowed question. As the tribunal, the ICTY, is winding down, and we do have now ICTY, and next to it we have the MICT. And I saw recently a filing that indicated that the ADC of the ICTY cannot necessarily represent the interests of counsel within the MICT. A question to you is, what is the future of defense counsel representation in an organization within the narrow sense of the ICTY MICT? If you have any.
Thank you very much for your question, Judge. It is actually something that we are presently working on, even though my colleague Lukasz will say I'm not working enough on it, but it is something that we are working on. There are some proposals on the table, Judge, and that is that we presently, the MICT, both components from ICTR and the component from ICTY, there are a total of 10 members. And that's it. We are trying to get the 10 members together to create an association, and the main proposal on the floor right now is basically that we would try to fall under the ADC-ICTY. Of course, I say this nobody knows this around, but it's a good opportunity to say that, because we feel that the ADC-ICTY could represent the interest of all lawyers practicing before the MICT. But we definitely believe that there is a need, even more so because there will be, as time progresses, there will be a further need to ensure that lawyers practicing before the MICT are able to do their work.
Michael.
I just wanted to supplement to this. As I understand it, those who are on the ICTY list and have been practicing for a very long time and are qualified are now being required to re-register, to resubmit documents, to get documents from their bar associations that they're qualified to be at the ICTY or the MICT, which is the same organization, the same people, only one moment they're ICTY and then the next moment they're MICT. And the question is, why are we having to do this? And that's why you only have 10 members, because it's taking me a month to try to get all the documents to show that I'm qualified to practice before the very same institution that I've been qualified for the last 15 years. And I think that's not ADC's fault, and it's not